join, and I appreciate the fact that she changed her schedule to be here with us, although she's got limited time, because today uh, I'm going to introduce the topic. It's wills and estates. Really exciting topic that everybody always wants to talk about so much all the time. Like we always ask that question all the time. No, not really. We're always recommending the wills and estates, but we don't really get a lot of questions about it. But before we actually open the floor to Raluca, I just want to welcome everybody back from a long hiatus. It seems like it's been forever since we talked. It was December the 3rd or December the 4th. And it looks like we lost a few people along the way, but I'm sure they'll be back. It's like the winter blahs. And we all know that this is being recorded. So this is the sixth session. We have four more left. I want to just let everybody know a few things that we're going to be starting to talk about over the last four sessions. Number one, Yvette and I we're very thankful for some of the feedback that we've been getting separately by private emails and so on the Facebook groups and on the YouTube channels that we're doing such a great job. And it means a lot to us because truly and honestly, this has been a work of love and progress for the past couple of years. And I'm the first to judge the quality that we're presenting. I always feel like it could always be better and that we could always learn more. But we got to start somewhere, right? So this is our first masterclass. We're going to be asking over the next few sessions, we're developing a feedback form. We'd highly be appreciative if you could tell us your honest feedback, good, bad, or ugly, because we are planning to either do another masterclass, live sessions, or we might even decide to just do pre-recorded videos that could be on demand and then do, instead of doing a weekly session where we do the masterclass, you can watch it anytime. We can always upload new videos with new changes in the environment. And then instead we can do possibly like bi-weekly or monthly live sessions on some Zoom call with anybody who is part of this group, basically. So that's coming. I just want to warn you because I don't want to just bring it on you to tell us how we did, but we're going to ask you to do that. And other than that, January 28th, for those of you that are in Toronto, we're already about to 30 people registered in a 100 seat capacity building at Gowling downtown. We think it's going to be packed. We think it's going to be oversold because it's oversold. It's free. There's no cost involved. But Gowling is promoting it. Trowbridge, which is our accountants partners, are promoting it, and the Spanish Chamber of Commerce Toronto in Toronto with 800 members is also promoting it because they have a lot of people looking to move to Spain and vice versa. So it is going to be sold out. If you're in Toronto and you want to join us, it's going to be a spectacular event. Please register. We'll send you the details. Now, without further ado, topic of today is the importance of having a will, first of all in Canada, but also in wherever your destination is. To talk about the side on Canada, Raluca, I'm just going to ask you to introduce yourself. And while Raluca is talking, if there's any questions that want to be put in the comments, Iveta can monitor the comments and let us know if there's any questions. But other than that, we'll just have a conversation like we did before. By the way, Raluca is one of my guests on my previous podcast. We'll send you the link. She talks all about wills and that as well. But tell us who you are, Raluca, and what do you do?
Hi, everybody. And thank you, Sergio, Serge, and Iveta for having me on in your presentation as a guest. My name is Raluca Soica. I'm a will and estates lawyer. I'm the principal of RMS Estates Law, and I practice in Toronto. My office is BVP and Shepherd, close to Fairview Mall. My main area of practice is wills and estates, but I also do real estate because there's a lot of real estate involved in estates. So I also do practice real estate as well.
Mhm.
And if you have any questions on wills, on estate planning for people that live in multiple places, that have assets in multiple countries, in multiple jurisdictions, I would be happy to help to answer your
Okay,
questions.
so why don't we start with that then, since you alluded to that. Now, I'm guessing that your expertise would be for a Canadian living in Canada that might have a property in Spain, for example, or in Romania or somewhere else. So that might be some of our guests. Like even myself, I'm thinking to buy an apartment in Romania but still live in Canada. So what happens there? What's the importance of that will?
So o- well, okay, it depends. It depends where your domicile is. If your domicile, so domicile is different than residence. Residence is a concept that's within the meaning of the Income Tax Act, and a domicile is within the meaning of estates law. So domicile means that you live here, you even though you may have an apartment in another country, it's for vacation or visiting purposes, and your intentions are to continue living in Canada, in Ontario specifically. I speak about Ontario because the state's law is provincial. So if you're domiciled in Ontario and you have a property in another country, we typically recommend, whether it's a real estate property like an apartment, or whether it's a bank account or anything else, we usually recommend speaking with an estate lawyer in that country and to see how your property passes. That's the first step. And then the second step, we recommend considering a will in that country. If it's done in that country, if it's appropriate, if it makes sense from a legal point of view. So the multiple will estate planning, where you have a will for the property in that country and then a will for everything else that's captured in your Canadian will that you draft here.
Okay.
And then depending, so that's if you're preparing wills, but then after the person passed away, then there's the question of how does this property pass? So there's the other side of the coin. Um, and generally, whether there's a will or no will, property passes in Ontario law, it matters very much where the domicile is. So that's why I mentioned it in the beginning. If the person's domicile was in Ontario, then all the mobile assets, mobile means anything but land and real estate. So all the mobile assets, bank accounts, everything foreign, they fall under the law here.
Ontario law. Okay.
So, yeah, under Ontario law. That's right. If the person's domicile was here,
Okay.
and then any real estate falls under the laws of that country. And this is generally, and it's not legal advice, and it's with exceptions, of course.
Let me clarify because it is can be confusing. And again, I think the importance to take away from this also is that there's probably no cookie cutter approach. Each person needs to have a consult with an expert, a specialist, where they live in Canada, because we have some people here from BC, for example. So what you're saying might be different in BC,
Yeah.
but also wherever they're moving to get their specific situation sorted out. But let me get this straight. So residency is tax purposes, right? So I could be the CRA can tell us I'm a resident of Canada or a non-resident of Canada
Yeah.
based on whatever the criteria are. However, can I be a non-resident of Canada and still have a be domiciled in Canada? Probably not, right? Because
I
I'm
have
probably
no idea.
if I'm a non-resident of Canada, I'm most likely living in the foreign country. I'm living in Spain.
Chances are, yeah,
Okay, so
yeah, but there are certain arrangements that we can't think of right now that fall,
well, that could happen.
um, that could
It's
happen.
important to know there's separate definitions, right?
Yeah, yes,
Okay.
yeah.
So let's start off with some more basic. I'm a resident of Canada. I'm domiciled in Canada. I want to be a snowbird to Spain, right? So um, I have a property in Spain. It doesn't matter where I die, whether I die in Spain or Canada, because I'm domiciled in Canada. The will of Canada takes precedence for my bank accounts, my real estate in Canada, but my property in Spain would not fall under my Canadian will. It would fall under,
Real estate, no, no. The real estate property does not fall under Ontario law. They won't even look at it.
okay.
They don't even want you to include it in anything, any calculations for taxes or anything.
So for
I mean, for
probate,
taxes, for probate fees, not income taxes.
gotcha. So if I've got property anywhere in the world, a will in Canada covers my stuff in Canada.
It covers your stuff in Canada, and it allows for the other stuff to be covered by the will here. But also the other side note that it's really important to note is it also matters, the laws of the other country also matters. So
Right.
let me make a distinction because I think this is a little bit of a confusing area, concept to grasp. Your all of these mobile asset bank accounts that you have in Spain will be included in probate here. So
Gotcha.
when your executors will apply for probate, you need to list the assets, and there's a certain tax that's payable on these assets. These assets, you will include the bank account in Spain, you'll include investments in Romania, anything that's mobile. But the real estate from Spain, real estate from Romania, anywhere else in the world other than Ontario is not included.
Okay.
Now, the laws of that country could say, wait a second, that's fantastic that you included in Ontario probate. We also want probate in our country. So it gets a little, it gets
I
more
understand.
complicated. Then the probate is resealed, and there's a whole process that happens. And then maybe they look and accept the will from Canada with respect to how the bank account is distributed. Maybe not, but from Ontario law perspective, that's included here, and you're paying tax on it.
Gotcha. And I have an
Okay,
answer to that now. Iveta,
you
go
pay
ahead. Yeah.
probate
Yeah,
tax,
we
probate
have
tax on
one
it.
question, not
Okay.
Go
specifically
ahead.
about fixed assets, but the question is from Dawn. So, what is the distinction between will and trust? What are differences in regards to taxes? That is the question. So, will
Uh,
or trust? What are the
will,
differences in
okay,
regards to taxes? Yeah.
got it. So a will is a document that you're creating where that kicks in once you're no longer alive. And in the will, you name your executors, so who will administer your estate, who are the beneficiaries, maybe your spouse, failing that, your children, and you can create trusts within the will. If you have a minor beneficiary, like a minor child, you would create a trust for a minor child. Minors can't receive money outright, as an example. Okay, the concept of a trust is different than a will. Trusts are not popular in Canada unless it's a testamentary trust. So unless it's a trust created by a will, and like for example, a minor trust, you don't have an option. You if you're gifting money to a minor beneficiary under the age of 18, you have to set up a trust in your will, unless it's like very little, like $10,000. Okay, so trusts themselves as standalone documents, not testamentary trust, or trusts that are set up, for example, a family trust. They're not popular vehicles anymore at all, because the tax rates for trusts and the reporting requirements have increased significantly since 2017. Trusts are now taxed at the highest marginal tax rate, and there's a lot of reporting requirements and tax. There needs to be taxes done every year on trust. So it's very onerous, and a lot of people just they're closing out their trust, and nobody is interested in starting out new trusts. Um, so that's people like normally people don't use trust as estate planning vehicle in Canada. They're very popular in the States. Maybe the tax environment is different than in Canada. I can't say, but in Canada they're not popular anymore. So, and then difference in taxation rates. The state itself, when a person passes away, it creates something called a testamentary trust. So there's a trust that automatically gets created where the executor takes possession of the deceased assets with the intention to distribute them to beneficiary. But it doesn't happen automatically because probate takes time, filing taxes takes time. So in the meantime, before the money is being distributed, they're held in trust by the trustee. So there's this trust that's being created, and the tax rate is much lower on this type of trust to allow the trustee to administer the estate. And then the tax rate increases significantly after 3 years. So that's high level the distinction between trusts. But the
And
takeaway is trusts are not used in Canada. In Ontario, they're not popular
Well,
anymore.
probably unless it's high $1 million accounts, maybe for alter ego trusts or living trusts, as we call them, Raluca. Maybe those are the ones that are still popular. Inter vivos
Uh,
trusts.
No, so the CRA is really those are inter vivos trusts or trusts that you create during your lifetime.
Yeah.
So those are the trusts that I was addressing, that I was saying they're not popular anymore.
Yeah.
The CRA is really closing in on
They think that there's a loophole,
you know,
maybe.
trying to increase tax rates and closing in
Yeah.
tax loops. So trust used to be good vehicles where you could set up an alter ego trust. That's for people that are over a certain age, or you could
65.
have yeah, you could do all kinds of things where you
Yeah.
could avoid certain tax, but that's being taken away now. So it just doesn't make sense to do them anymore because the benefit is gone.
Okay.
Yeah. All right.
Um, any other questions in the chat there, Iveta?
Uh, well, in the chat, I'm just pointing out maybe some questions people would like to ask. Um,
You have a
some
question,
pointers.
Iveta?
Preferential shares. If I mean, we know it's 350,000 in Ontario. That is if somebody doesn't have a will, right, Raluca? So what happens if person does not have a will? I guess let's have that question.
So if somebody passes away in Ontario without a will, a lot of people, especially East Europeans, they think that
It will go to the
their
spouse.
money goes 100% to their spouse, which is
Right.
not the case. The classic lawyer answer is it depends. So assets that are joint, like with a spouse, for example, like a house, their home where they live, if it's joint, then yes. If it's held in joint ownership, then it goes to the surviving spouse. Bank accounts go to the surviving spouse. Um, um, Registered assets like an RSP or TFSA that have a beneficiary, that has the spouse as a beneficiary name, that goes directly to the spouse. Everything else, sole bank account, investments, that's a big asset. A corporation that has value. So not just a shell corporation that it's not used, but that has maybe investments in it because the person never withdrew all the money that was in it, or it has resale value. All of that, the spouse only gets the first 350,000, and then the rest is divided between the spouse and the children. And it depends how many children. So the
Right.
shares of division depends on how many children
Yeah.
there are. Yeah.
Now, if I may, Sergio, I
Yeah,
love the
please.
topic, guys, and we want to encourage you to ask questions. Maybe think outside of the box. But the biggest question comes down to, the highest rate of divorce is probably in North America. I don't know. I'm just guessing, but it is extremely high.
Mhm.
People live new lives, move to Mexico, move to Spain, and they forget about maybe responsibilities of what happens if. So if it is a blended family, let's say I have
Mhm.
kids from my previous marriage and my spouse has kids from his previous marriage. What happens if I die and there is no will? We're
Oh.
screwed, right? My kids are
Uh,
screwed.
so again, it's the same answer
Depends.
it's the same answer like earlier. So if they pass away, so if they're married, okay, that makes a difference in estate law. If they're married or live in common
Married
law,
or
makes a
common law.
big difference. A common law spouse does not take it. They're not considered. They're not getting the 350,000. There are some remedies for common law spouses, but married spouse gets most of the rights. Um, so it again, wherever the married spouse is a beneficiary, they get that asset. So for example, if they're a beneficiary of registered assets or PTFSAs, they get the asset. If they're joint on the home, they get the home. Anything joint bank account, they get it. It is what it is. Um, and then again, the first 350,000 go to their married spouse, and then the rest gets divided equally between their married spouse and all of their children. So that would be their children from their prior marriage. So children may get something or they may not, depending on how much money is in the estate and how the assets are structured.
Yeah.
But Yeah, so that's why if you have a will, you can think about plan for this ahead of time and say, okay, I really want my children to get something, and you'll know what the relationship is with your spouse. Um, and if you want your spouse to receive more or less, or it really, I find that um, for people, it really depends what stage they're at in life. So if with their new spouse they have a child that's a minor, they will tilt more towards giving more to the spouse because they really want to take care of that minor child. They feel like the older children have received, have received help for a certain amount of time longer than their current minor child, and they want to, there's a sense of protectiveness over the young child. If they're at a stage where everybody has adult children, they don't have children together, then it's different. Then they may give substantial amounts to their children from their prior marriage, and they may leave either some money or residues of the spouse or a life estate. That's how we call it. It's a trust where they keep their money in trust for the life of the spouse, and then the children get the leftover once the spouse passes away, and there's something left in the trust, the children get the leftover. So there's all kinds of
Thank you.
conversations that take place depending on where the client is at in life.
Yeah, it's very personalized and private. Raluca, we have two questions actually in the chat, so I'll read
Yeah.
them out. One is they're from John. So, what constitutes the actual domicile? Is it an actual property, or can it be an address such as PO box?
It can't be an address. So domicile means it means that you live here in Ontario, and it means that it also takes into account your intentions. You intend to live here indefinitely. You do not plan to change your residence. You don't plan to move. So if at the date of death, if there's a person, the person who passed away has traveled in between two countries and has spent a lot of time outside of Canada, we have this discussion with the executor. Were they domiciled here? That's very, very important. So did they have intention? Did you have
Yeah.
conversations with them? Were they just traveling?
So
It's
it could be
fine to
like
travel for medical reasons or
could be
for
like the
pleasure
snowbirds,
and then
right?
come back.
Could be like the
Mhm.
Florida snowbirds, right?
Yeah,
You're
yeah,
going to
yeah. You
Florida for the winter, you're coming back and you're staying in Canada, right? So that's
you yeah, and your
yeah,
intention is to continue living in
right,
Canada, and by all intents and purposes, this is where you live, and you just go for fun somewhere else, and then you always intend to come back. So it's
right.
the intention matters a lot in determining domicile.
Raluca, there's a follow-up from John, and then Dawn, I'm going to address your question.
Yeah.
Not looking to keep property in Canada while in Spain. So would my will in Ontario become void? Very good question.
No. It's a very good question. Yes, it wouldn't become void in the sense that it would be invalid. You have your will done here, so a will doesn't become invalid just because you no longer have property in Ontario. There are very specific requirements to void a will, to revoke a will. What would happen is if you move to the other country and then you get a will done there, that would probably revoke your will here. So if you take that action, that would probably revoke your will here. And but if you don't,
I'm
I
thinking
I
also, I had this discussion with Iveta before you came on, and I was thinking,
okay.
well, what if I have like siblings? I have nothing left in Canada, but one of them passes away and leaves me something in Canada. Would my will still not be then important to have because I have now
Mm.
property that's been left to me?
Not necessarily, because if you live in another country, this estate will be administered and you will get the money and then you liquidate it and move it. Unless you want to keep it in a real estate
What if it's
property.
a
You want to keep
cottage?
it here?
What if it's a cottage or a
Okay, so
property?
it's a property that you don't want to liquidate. And you're going first of all, that you need to talk to an accountant because the tax consequences of that just sounds a little high
Yeah.
for just pleasure seeking. But
I get
So
it.
that's the first, and most people decide not to keep the property here because of because of taxes are so high. Because there will be capital gains accumulated on it, and then if you're not a resident, then I'm not sure what if they're higher or
Before
not
Somebody
a resident.
has to pay the
I
tax,
want
and if
to thank you so
yeah.
much, Raluca. Exactly what we've been saying all the time. You need to talk with an expert to go through this to make sure that
Uh,
it.
Serge, I do have
Yeah.
another question from
Go ahead.
Don. I have to address that.
Go ahead.
Raluca, here's the question. So, what if you name your adult child as beneficiary on assets and you have a will and real estate in Canada and Spain? What happens if you remarry in Spain?
Oh, wow.
Oh, wow.
That's like
I
really.
know it's a loaded. Go grab your glasses of
First,
wine.
I
Go.
would say speak to a Spanish family law lawyer. You see these countries there. I'm learning from my clients. This is not, I'm not trained in the laws of other countries, but I'm learning from my clients that are Spanish. I've had Spanish, Portuguese, Romanian, Dutch. So there's these regimes, especially in like Spain and Portugal area of the of Europe, where when you get married there you choose the regime of separation of property when you get married.
Because
So either
divorce
you
is
can,
based on the provincial law here, probably the same thing over there, right?
so I'm not sure. So they need to speak to a lawyer in that country. However, the other thing I learned from a family law lawyer in Ontario, which I'm not practicing family law, but this is just for fun information purposes. She had a client that just had property in Canada, but was living in Jamaica, and she had four houses in Canada, and she was going through a divorce, and they were they were arguing, the lawyers were arguing about whether the law of Canada applies or the law of Jamaica applies. So it appears that it's not clear cut the regarding separation, which the law of which country applies. As I always recommend to my clients, in Canada, you can get a contract, you can sign a contract with your spouse. It's called a marriage agreement or a cohabitation agreement, and you decide how you split the property, and that's the best peace of mind that you can have.
Thank
And
you.
I think although the more assets you have when you're getting married, because if you're both starting out with two nickels to rub each other, who cares, right?
Yes,
But if you're marrying later in life or it's a second or
yes,
third, then it's probably recommended, right, Raluca?
yes,
Absolutely.
absolutely. And I
It
think her question was if the assets in Canada, so if she's naming her adult child
kids.
as
Yes.
beneficiary, I
Yeah.
mean, by Ontario law, whoever you name as a beneficiary to your RSPs, TFSAs, that's who gets the money. They don't even look at I mean, they look at the will.
They do.
They do
Yeah.
because sometimes there is a clause in the will that can revoke those designations. But in the absence of that, they will just pay the money
Yeah.
out.
This is the
Um,
important, this is really important. I want to highlight this, and I know that you have to go. You only said you could stay till 7:30, so I'm mindful of the time. Um, I've seen this over and over and over again. People die, and then if the will is not very clear cut or whatever, there's a lot of problems afterwards for the family. Not because they don't love each other or whatever, but there's miscommunication or this or that or whatever. So it's really highly recommended that it's very clear cut because Raluca's right. If there's a TFSA with the beneficiary, our job at IG, we'll get the death certificate, we'll confirm the executor. We sometimes we don't even have to probate the will because if we have
No.
a beneficiary on file, it's going to the beneficiary.
Correct.
And but now that doesn't mean that they're safe because someone else could contest the will
yes,
and then go
yeah,
after the beneficiary that has now the money. We're out of the picture at IG. We're not, we've done our due, we've done our diligence. We've
Yeah.
confirmed what happened. We've sent out the money, but then after that, that doesn't mean that it's over. So really a lot of good stuff, Raluca. If you want to stick around, by all means, I have queued up. I actually did find the video we have of Inma and Maculada, a lawyer in Valencia, and we asked her the question about wills, and it's on our YouTube channel, but I've queued it up to show what she says about having a will as a Canadian in Spain. So feel free, Raluca, if you can stay, by all means. If not, thank you very much for your time, and we'll provide your information to all of our group afterwards in case they want to reach out to you for a will or questions afterwards. Okay?
Thank you so much for having me,
Thank
Thank
Surgeon
you,
you.
Rilla.
Iveta. Thank you.
Thank you, Relica.
All right, so let me bring up, let's see here. How do I do this share again? I haven't done this for a while. First, I have,
Well, there's a green arrow.
I found it. Thank you. All right, can
Where-
everybody, oh, I forgot to share with sound though. So let me stop sharing because we need to have the sound. Now, some of you might have seen this if you're following us on the YouTube channel. Some of you may have not. Um, Yvette and I are diligently looking to find people to interview. No, I can't find. Okay, sorry.
It was just there.
I know, I know, I know.
All right. While you're finding the video,
You
just
talk,
give me.
you talk, so I
Yeah,
can.
I'll talk. So once again, the topic of wills and estates, it is extremely important, and with some of our designations behind the scenes, obviously we know general things, but it's the lawyers who will advise you further. And now that we have a video, let's play the video, and then we will address a couple more questions and maybe issues that I want to bring up.
You're
Okay.
also doing wills for people in Spain?
Yes,
Okay, so expats are coming to Spain. It's recommended, right, that they have a will in Spain?
yes, of course. It's recommended to have a will in Spain because it's the advice is similar to the power of attorney. The thing is here in Spain, to sign a will is quite cheap, and also can avoid many problems in the future. Because even if you have a will in your country, in Canada, to sign another will in Spain for your assets in Spain may avoid many problems in the future because you don't need at the time when you will have to use the will, you don't need official stamp or translations or whatever because you are making a Spanish document, and it could be valid only for your assets in Spain, so you don't need to involve your will in your country. And also as a foreigner you could request, and you are entitled to do so, to sign the will according to your personal law. So you could sign a will in Spain according the Canadian law.
Oh, really? Okay.
So the Spanish law doesn't affect you at all.
I
Mm,
wonder though, I guess if you die in Spain without a Spanish will and you have a property, does it go under Spanish law then because there's no will? Or does it do you know?
In the case of Canadian citizens, the applicable law will be the Canadian law, the personal law. But in the case of European Union citizens, the applicable law will be the Spanish law,
Oh,
which is totally different to any
wow.
other regulations in a different world. Yes, because we have a EU regulation stating that the applicable law is the applicable law of the place of your residency, not your nationality. So for the Canadian citizens, won't be a big problem because the Canadian law is the applicable law. But the problem is that we may need to get some documents that will come from Canada, so we will have to legalize them,
Right.
provide a legal.
It's still a complicated mess, basically. So for me, that I'm also European passport hold, like I'm part of the European Union, so I
Mm,
hold both passports. If I were to purchase a property in Spain, I would be under the European law if I were to die with property, correct?
correct. Yes.
Okay,
Yes.
that's interesting to know.
Yes.
Okay.
Yes.
And that's a whole new thing to learn because there's completely different taxation, right? It's on death, it deemed to be disposed as well, most likely. And
Yeah.
Yes,
I
that's
I'm
another
scared.
thing. If you don't sign a will in Spain, it's a miss from the beginning till the end, because first the documents that you need, it's for the for the heirs, it's a problem. For any small thing could cost a lot of time and money. But also for the taxation could be different if they cannot prove that you were resident in one place or another. I think that you are living a problem because they need
Yeah.
to provide many documents to the Spanish administration. And if you sign a will, again, the cost is minimum. Also, the will in Spain is quite easy. You only have to appoint the beneficiaries. So if you buy different properties or do whatever with your money, you don't need to change the will as long as you don't change the beneficiaries. So I definitely recommend to sign a will if you are buying a property at the time when you are buying the property, if possible.
So quite a few
Got
closing
it.
costs. Maybe
Got it.
that's something we'll
Excellent
get into in
advice.
the next time of these costs,
Mhm.
because as financial planners in Canada, when we're working with people like Canadians that want to move, we want to get a good idea of what is the actual costs of picking up and leaving, because we can talk about the withholding taxes and so on, but these
Mm.
one-time costs, the airplanes, the consultation fees, the property purchase, these are all different numbers. I'd love to get into that with you in another session if you have time. Today, thank you so much. If someone wanted to get in touch with you, what's the Okay. So, any questions? I mean, obviously, if there's questions, we won't be able to answer them today because we'll have to go to Inma. But Inma was a spectacular guest, and she just reached out to me actually the other day. She sent me a WhatsApp reminding me that the Golden Visa is expiring April the 3rd. So she's open for us to have a chat with her about that if anybody is interested in that. But all right.
Awesome.
Iveta, anything to add before we move on?
Uh, well, if anyone has any other questions, I mean, what we face in our decades of work in our financial planning business is truly lack of planning, and this is something we advocate and we urge our clients and friends and prospects to address sooner than later versus facing the consequences of constantly changing laws. For example, just a couple of years ago, a law changed on a spouse and divorce versus new marriage. If the old will used to be voided, well, the new law is that the will stays intact, and then those previous spouses will get your assets if you don't do anything about that will. And also directing, calculating. Our softwares help us figure out truly what you're looking at from distribution tree through what are potential taxes. That is very important to address as well. As for will and power of attorneys, we're all happy and doodly when we are healthy and traveling, and we hope that this is how it's going to stay. But if there is a need for someone to step up in case I lost my marbles, but I'm still alive. So if I'm alive, no executor, no will is going to be valid at that point until I actually die. So I need a power of attorney, one for health, one for finance. Could be one same person. But these are very important aspects to address, because who is going to make decisions on whether to pay for my care or for my wherever I am, and whether to pull my plug? Those are the decisions I will make prior while I still have everything here. And it can always be changed. You can always adjust it and clarify it, or for the will, you can always add a codicil. Codicil is just an addition to the will. You don't need to change the whole thing. So yes, we have plenty of stories to share. We have a question there from
Yeah.
Dawn. Do you want to read it out
Yeah,
to
I
all of
saw that.
us?
So Don is
Yeah.
asking, do you have to purchase the property in Spain and sign all the documents before April deadline for Golden Visa, or can it be part of the process of finding the property? So from my understanding, from what I've read and listened to, you have to make the application before April the 3rd. You have to sign those documents. Now, I would highly recommend that Dawn or whoever is in this area of reach out to Inma. We can provide her information again. She specializes in this. She will provide you a complimentary consult by Zoom. It's her specialty to figure that out. And she also can talk about other visas if that is not within the time frame to get this done before April. And you're like, okay, now what? There are other visas that she can talk to you about as well that might make sense. Sergey is online as well. Thank you
And
very
he's
much, Sergey.
confirming.
So Sergey is in Malaga, and he says you have to file the documents by April the 3rd, and he's been our guest before, so and he's in the know because he actually, I'm going to queue up another video that at the last moment, again, because I'm sorry, I was in the Mexican sun and I came back. I said there's going to be a seminar, an expat session coming up, and I totally forgot to reach out to ask Sergey if he had a lawyer that we could ask some questions of. And within 24 hours, he ran off to his contact and got Raphael to give us a little bit of a note. And I'm hoping to reach out to Raphael and see if we can get more from him. But let me cue that up and see what he says, okay? Share with sound, and I should find it first before I share it. Give me 1 second, everybody. You better talk.
Sorry, I'm typing to Sergey. Sergey, I have a question there for you. This golden visa, is it the 500,000 euro limit? That's the minimum for that golden visa? Maybe?
I'll answer for
Okay.
Sergey. Yes, it is.
Oh, yes.
Oh,
Oh, can you hear me? Okay.
Yep.
Yeah, for the real estate, it's 500. So
Okay.
there's other options. Right? You can invest more money in the different vehicles, but for real estate, it's 500.
Got you. Thank you.
okay. Can we see Raphael here on the screen?
Yes, we can. Let's
Okay.
see if we can hear him.
Hello everyone, my name is Rafael Fernandez Figares and I'm the director in Martinez Echevarria Law Firm in the offices of Malaga, Fuengirola and Benalmádena. We are talking mainly about the real estate department which I lead. The idea of this video is...
Sorry, when he says real estate department, he's talking about legal law for real estate, not realtor.
Yeah.
I
clarified that as well with
informing you about the necessity of granting a Spanish will, obviously here in Spain. The response will be very straightforward, and I will say that yes, you will need to do it. Although it's not a compulsory requirement, we advise the clients to do that because if for any reason in the future any of you die, and we are talking about mainly foreign people that live abroad, if there is not a Spanish will, the requirements for the formalization of the inheritance here in Spain is more tough, because we will need to go to the country of origin and request declaration of heirs, translations, get the documents apostille, deal with the certificates of law, and at the end it's really a hassle. So we always advise our clients to do the Spanish testament and discover that if something happens in the future, you only need to contact your lawyer, you only need to contact ourselves, and we will do the job on your behalf. Of course, any question, anything you may need, I'm here at your absolute disposal. Thank you so much and have you all a lovely day. Bye-bye.
Okay, I want to vote for this guy. I like him.
That was wonderful.
That
So
was quite, yeah. Sergey, tell him thank you very much on all our behalf. That was perfect in like 1 minute and 45 seconds. So
I will, sure.
that was, so there you go. When he started mentioning to, if there is no will and that you have to get the clearance certificate from country of origin, clearance certificate is probably, if everyone knows, this is when we die and our executors deal with our estate, pay all the taxes. Once all the creditors are paid, then we get the clearance certificate. This process can take anywhere from minimum 12 months up to a maximum 3 years, 4 years. Well, after 3 years, the estate tax is going to the highest tax bracket. Raluca probably mentioned that. It's a graduated estate rate that after 3 years, then it's a highest marginal tax bracket. If the estate is not settled, this is the tax owing to the government. So only then do you get the clearance estate. clearance certificate. And this is what this lawyer is referring to. So the process can be very painful. So if you guys buy the property in Spain, Portugal, wherever it is, adhere to their laws. We're kind of concentrating on Spain here. I don't know whose influence is that, but
Yeah, I wonder.
but it is extremely obviously important to ensure that at the time of the purchase of the house, deal with the will, get it settled in, have it in place, as the more we discover, the more we understand it will be applicable for that property only, and that's how you'll specify it.
Yeah, and we actually just talking about the will here, we should also expand maybe in another session or video while you're alive the powers of attorney, because we didn't even touch about that, right? For example, if you're in Spain and you're incapacitated, the powers of attorney that would still be valid in Canada or whatever, like that's another topic. Suffice to say, it's going to cost. So these are some of the I alluded to in that interview with Inma. And from the very beginning, our very first masterclass, we said there's three things, right? There's financial, there's emotional, and there's logistical. So, and we also talked, well, if you're young enough or crazy enough, you just say, okay, I'm buying my ticket and I'm out of here. And then I'm just going to deal and see how the dust settles, right? But if you want to just plan ahead, then these are things that you want to consider. And our job here in this masterclass is to highlight the different things so you can worry about it and have a glass of wine. Don't worry, it's cheaper in Spain. You can buy a bottle for two euros, but at least you're aware of what you're looking to get done. Okay. Um, I don't even know what's next. Okay, we got a couple. Oh, so yes, I want to. What do we got here? Global from Yvette.
That's me. I just keep reposting it, guys. If anyone.
All right.
Sorry.
One question Yvette and I get often, at least I know I do. Um, Number one is we every time when we meet with someone, when we consult with someone, we do ask, do you have a will? It's our job to make sure that you're covered and protected and so on. And if you don't have a will, then we recommend you get one. And then so there's most will ask us, do you have good lawyers? So we say, yeah, we give the names of two or three lawyers, and then off you go to the races. And sometimes people say, but how much does it cost? And each lawyer is going to charge a different fee. I know that in general, just a basic will is going to be anywhere in the range from 800 to 1200, or I mean, I'm not the lawyer, but I think that's kind of the going cost. And then if you add trust and so on, it might go higher. So many times I've been asked by clients and by others, well, what if can I just write a will? Can I just do that will kit and so on and so forth? I personally don't typically recommend that because you're leaving it to your own devices to make a mistake. You're not, I mean, you go to a lawyer, they've got the schooling, they've got the education, they've got the E&O insurance, all right? So they're basically signing that it's a correct document. Whereas if you write a holographic will, which can be valid, I've been told, but if you make one mistake, it's just opening it up to hassle. So IG Wealth has thought about this for our clients, and Yvette is going to talk a little bit about what we've done to help kind of ease this, where once we've consulted with someone and we understand what the complication is, we will think about whether we should recommend you to go to a lawyer, or if the cost is an issue and you just simply, it's a simple thing, then we have partnered with a company called Clear Estate, which is a fairly new partnership and relationship with IG. I'm not saying it's the right one or the wrong one or the best or the worst, but it's something that you should be aware of that it's we can offer you. And Nevada, I'll leave it up to you to talk a little bit about it and present it. And if any questions come up, I'll monitor the chat.
Well, I'll just talk about it then.
Okay.
Very, very, not in major detail, but when do we choose to go to an individual or to a will kit online, or utilize a company such as Clear Estate? Well, just like Raluca was saying, it depends. It depends truly on how complicated is the current scenario? Is it a very simple, straightforward? There's no outside or kids from other marriages involved. Then maybe it is a simple way, and you can maybe address it in any manner you prefer. Now, about Clear Estate, I'll just mention a few facts. So it is an online platform which you have access to 24/7. You could be here in Canada, you can be in Spain, in Africa, in Mozambique, or Antarctica, as long as you have internet. You have access to the platform. You can upload any changes, which would be called codicils. You can change it at any time. You have all your assets mentioned on that platform. The will is created by professional lawyers. There are many of them on staff, I believe, in Clear Estate. You're also guided and advised in the beginning stages what should be advisable in your specific case after a full review. So I find that is a beneficial factor to outside of the will kits, because we don't know what we don't know. And once the questions are asked, and maybe it will direct you to thinking, oh my God, you're right. What about my dog? I didn't mention it anywhere in my will. Who's going to take care of that?
Oh my God,
Is there any donations I want to do?
yeah, no, you know what?
That's a whole big.
You brought that, dogs seem to be like a central theme of this
Oh,
masterclass. It's like,
it
and,
is.
uh,
Yes.
you're absolutely right. I'm
You
actually
have to address that. The will kit is not going to have a space for it. You
yeah,
have to really address that. Well, back to Clear Estate very quickly. What is really tremendous about them specifically, if the situation is slightly more maybe complicated, the executors have, it is a heavy duty job to do. It is not a piece of cake. Most of the times we name our kids, those who have kids, as executors. Be rest assured, if you've gone through it for some of your maybe parents or grandparents, it is a full-time job almost, and you have a full right to charge a fee. And if there is any other siblings, that might become a serious issue if you, God forbid, charge anything from estate. Hence, a Clear Estate will take care of that. There you go. Serge is actually pulling it up. They will guide the executors fully. Number one. Number two, what's important is the fees and filing fees. To get that final clearance certificate, is you need to do all the T1 final returns. That alone could cost thousands of dollars. Here in this case, with Clear Estate, it is included in their offerings. So I wanna leave it quite general. There
yeah,
are different packages to consider, but I believe what me and Serge are trying to present to you, that you have choices. And if you wish us to guide you a little bit further, one or the other way, or provide you with referrals, we are going to be more than happy to do that for you and advise you on that.
yeah, yeah. So
And
thanks
once
for that,
again, we
Iveta.
have resources.
Yeah.
Yes, thank you. We'll leave it at that. Yeah.
We're trying to be, we want to, the
Back
reason
to
we're
you.
kind of a little bit reticent is that we don't want to promote one over the other. We feel that, I feel personally, the best advice is always talking with a professional that you can get along with, and you interview them, they interview you. There's a connection, you like each other, you trust each other, you can give them a call on WhatsApp. I mean, some of the reason people are working with me and they're moving to Spain is because they can send me a WhatsApp and I can get them their money easily instead of having to call the phone number or call center or whatever. Um, if you're comfortable with online and you can do it on your own, then ClearState is definitely an option, because picking up the phone and getting in touch with the lawyer or whatever might be difficult. I don't know. The point is that it's important to take care of your estate if you feel it's important. If you don't care, let the family take care of it. Again, there's nothing right or wrong with that. We're not trying to tell you how to live your life, but these are just things that you want to, if you have kids, obviously. If you don't have any kids and it's just the two of you, okay, make sure everything goes to the spouse and you're good. Whatever. Everything
Yeah.
else can go to the government. right?
Raluca also mentioned the beneficiary designations, and she is absolutely right. So whoever is the beneficiary in Ontario, we're talking Ontario. In Ontario, we have a probate fee. Hence, if there's no beneficiary on accounts and it goes to estate, all of that money will be probated, number one. Number two, that what I'd like to mention is TFSAs. Ensure that there is successor holder beneficiary on that tax-free savings account. Successor holder can be only a spouse. The major difference between beneficiary and the successor holder is the fact that if I die, my husband will get my TFSA. If he's a beneficiary, he will just get that amount and he can invest it. Maybe if he has enough room in his own tax-free savings account, he can add there, and the difference may be into non-registered or RSPs. But if he's a successor holder, then all of my TFSA is going to be transferred into his TFSA over and above the allowable limit. So if he has 100,000, I have 100. He utilized fully his TFSA room. My 100,000 will be added inside his platform, inside his plan. No questions asked. That is successor holders.
Yep.
So just to finish off, the executors. So the beneficiaries get the money, but the executors are liable for the tax bill. If the beneficiaries are not executors, then you have to question where are going to take the money to pay the bills. Are they going to run after the beneficiaries? Hey, we still need to pay that RSP that you benefited from. I need to pay half of it in taxes. I don't have the money. You're the beneficiary. I'm executor. Where am I going to take this money? Well, good luck. This is where lawyers thrive. I'll leave it at that. It's 7:57. We're here to answer your questions, guys.
Okay, so in the last 3 minutes, because we're going to end on time like I always like to do, obviously we're going to be here if you want to stay on to ask questions, but um, I'm going to show you two reports, and it's a segue into the next meeting, and it's about surrounding estate planning. However, one of the other things I want to start talking to you guys about in the next 4 sessions is Iveta and I are going to start sending you our calendars because we're recommending highly a 30-minute complimentary consultation because everything we're talking about here, it's not potentially good for everybody. Even what Iveta just said about successors and beneficiaries, I've come across situations where the family structure was in such a way that the family had 3 daughters, one condo, one home, a few RSPs, and the point was they wanted to have equal to each $3. And there was no way possible to do that by putting beneficiaries on the recommendation at that point was put everything into the estate, have it flow through the estate, pay the taxes, and then equal portions. Otherwise, it was too cumbersome to do that. The point I'm trying to make is you can only find that out by talking with a consultant such as us, where we will get your information, figure out what's important for you, for your lifestyle, and for your family, and then make the proper recommendations. We're not charging a penny for this. We're doing this because we are in this category of helping Canadians, and especially Canadians who dream about becoming expats. And one of the things that we're talking about next week is insurance, which can be very important for whether you have assets here or in your new country of origin. One report that usually shocks people is the one I'm going to share right now, is the estate report that our software calculates what your insurance, what your estate cost would be when you die. And it basically tallies up your whole entire, assets, and we assume a certain date of death, whatever. And in this case, for Mark and Mary Expat, without planning with us at IG, their estate cost was $560,000. And I'm not going to show you what we did to implement to lower that, but with some implementation of some strategies and tax strategies, the new cost for the estate was 376. We didn't do anything illegal or anything like that. We just used different ways of different accounts, whether it's TFSAs or taking money out of the RSPs earlier. I'm going to leave it at that because it's 8 and I promise to finish on time. But uh, if you have any questions, once we send out the email, feel free to send them back to us. Again, we'll provide you with our online booking system, and it's going to be called 30-minute consult available. Uh, Meetings on Tuesdays, on Thursdays, the calendar will tell you when there's available time. And you can pick either
No,
me or Iveta.
sorry, the meeting's here because today it's Thursday.
Oh,
Our
right.
next
The
expat.
next one is Tuesday, and then the next, I think it's
We
usually
are
Tuesday. There
missing the
might be a
20.
Thursday. The
Yeah,
28th is on a Tuesday, so the next one will be on a Thursday.
yeah.
But that'll be in the follow-up email for this event. So thank you so
And
much.
also hold on, Serge, hold on. Who's
Yeah.
speaking next week?
Oh, thank you so much. And we have Demetrios from Trowbridge. You guys should all be salivating to come next week and tell all your friends because now we're talking about the tax situation. This is the guy that will tell you, answer questions about what are the tax implications of all your assets, all your incomes, living in a foreign country from the Canadian perspective. So it's a really good one that you're going to want to meet. If you can't make it in person in the January 28th, because he'll be the speaker there as well, then this is the time to ask him the questions. Send your questions in advance if you want, so we can prepare that for him. Okay?
Yes.
All right. Thank you, everybody, and have a wonderful
Thank you,
evening.
guys. Thank
Stick
you for
around if you want
staying.
to say hi, and we'll stay on for a few more minutes until everybody leaves, or I will.
Okay, please share the